you shall be heard. God save these United States, the great state of Florida, and this honorable court.
Be seated, please. Good afternoon. Welcome everybody to the First District Court of Appeal. And I understand we have some students here from either Florida State as I understand it. At any rate, after the oral argument, if the students would like to stay back and ask the court some questions, we'd be happy to do that. We couldn't talk about the specific case, but we could talk about procedure and process and cases in general context. Are both counsel ready to proceed?
Yes, Your Honor.
And have you all decided, as I understand, how to divide up your time?
Yes, Your Honor.
And I'm not going to monitor or police that, so you may proceed.
May it please the court, Brian Gowdy on behalf of Shaun Lesnik, the appellant. I think the briefs are cluttered, and I'm going to try to declutter it in the next 20 minutes. I want to talk about 3 of the 5 claims. I told her before you came out 6 minutes. Sorry, Your Honor.
That's right.
I apologize.
No, that's fine.
And the 3 claims I want to talk about are the strict liability design defect claim against Duval Ford, the strict liability warning defect claim against Duval Ford, and the negligent warning claim against Birkins Chevrolet. And as the Supreme Court reiterated just 2 weeks ago today, a product is unreasonably dangerous in the context of a design defect claim if because of its design, if the product fails to perform as safely as an ordinary consumer would expect when used as intended. And I think it's important, as the Supreme Court reiterated and rejected some case law from another DCA, that in Florida we follow the ordinary consumer test about design defect. I think it's also important that what the Supreme Court reiterated, that when we're talking about strict liability, you don't have to prove negligence. What Duval Ford knew or didn't know at the time of the sale is not important. What's important is, was the product unreasonably dangerous based on the expectations of an ordinary consumer?
Well, let me ask you about the unreasonably dangerous. Mr. Moore, your own expert, or your client's own expert at the trial level, offered no opinion as far as whether lifted trucks are unreasonably dangerous. What material issue do we have in dispute still that should cause us to send this back because of a dispute of fact on the unreasonable dangerousness of the truck at the time it was sold by Duval?
Right, and that's why I started with the ordinary consumer. If Mr. Moore had offered such an opinion, or if any of their experts offer such an opinion, I would submit it's improper. This is not a professional negligence case where you need an expert to come in and say what the standard of care is. What you need is an expert to explain the dangers from the design, what the increased dangers are, and then it's up to the jury, as a jury of ordinary consumers, to determine whether that's unreasonably dangerous. And in fact, if you read all of Mr. Moore's deposition, there was a very interesting dialogue between him and Duval Ford's counsel, where Duval Ford's counsel said, well, you've driven lifted trucks. Tell me how you feel about it just driving the truck. And he said, I can't do that. I'm an engineer. I know too much about it. I can't be an ordinary consumer, effectively is what he said. So I think it was completely appropriate, and in fact may have been, if we get to the jury trial, when we get to the jury trial on this, the expert should not be opining on that. That's taking away an issue from the jury. And it was the law for 300 years under the common law that experts could not opine on the ultimate issue. And it was only in 1952 when the Florida Supreme Court said, well, you may opine on the ultimate issue. But there's certainly no requirement that you must. And
but you got to have some factual dispute to survive summary judgment.
Sure, and let me tell you what that is, Judge. I'd like you to, all of you, to go to page 2082 of the record and read the 4 pages there. 2082. This is a bulletin from Ford Motor Company that was discussed by Mr. Moore during his deposition. And this is what it says. And they're talking about unlifted trucks at this point. And by the way, it's not that all lifted trucks are defective. It's whether this type of truck, this F-250, should have been lifted, whether that made it unreasonably dangerous. And this is what the Ford Motor Company said. It has come to our attention that owners of the F Super Duty 250, 350 have experienced severe steering wheel and front wheel vibrations and oscillations after traveling over a bump or dip in the road. Then it says that Ford and the National Highway Traffic Safety Administration have been studying this. And then it says, what is the issue? Your vehicle, the F-250, may experience shimmy, a severe vibration, and oscillation in the steering wheel that begins after the vehicle travels over a bump or dip in the road and does not dampen out by itself. This sounds very much like what happened to Mr. Lesnik.
But wasn't that, and I may be wrong, and I was not able to pull it up right here as we sit, but wasn't that April 2009 when that bulletin came out?
Yes, sir, but that's why I started off with strict liability. And I said the knowledge doesn't matter. The question is whether the product was unreasonably dangerous. It's not what Duval Ford knew in 2009. The question is whether this product was dangerous. And then the jury gets to decide whether it's unreasonably dangerous based on ordinary consumer expectations. And if I could continue on, this is what Ford Motor Company, not Duval Ford, Ford Motor Company says. What should you do? Do not make suspension modifications. Ford does not recommend the installation of aftermarket lift kits, stabilizer bars, or replacement parts that are not equivalent to the original factory equipment. Ford Motor Company itself has said, if you lift this vehicle, you've created a danger. So we have evidence, very strong evidence, and Mr. Moore explained it during his deposition about the dangers of this product. And the fact that the dangers came to light in 2009 doesn't mean that it wasn't unreasonably dangerous in 2007. If we're now in negligence, the timing would matter, but I would like to point out what they did know in 2007. Duval Ford's own warning at page 1363 attached to the affidavit of Mr. Sweat, this is what they were purportedly telling all their customers. The installation of a lift kit will modify the suspension of your vehicle, increase the vehicle's height, cause it to handle differently than a factory-equipped vehicle, and may greatly increase the risk of vehicle rollover. So they clearly had some knowledge, not that that's relevant for products liability, but they had some knowledge. And also, as we pointed out in our brief, they knew that the warranty by Ford would be voided insofar as any damage caused by a lift kit. So we had lots of facts, Your Honor, about the danger of this product.
Remind me of when the Duval, what you just read came out. What?
The last two things I read were contemporaneous with the sale to Mr. Sweat. This is the warranty, and this is actually what Duval Ford claims they gave Mr. Sweat at page 1363 of the record. So what they say they gave Mr. Sweat noted the increased risk.
Okay, the original owner, right? Okay.
Right, the original owner. I'm sorry, Your Honor, for not being clear about that.
Well, let me ask you this question about the affidavit. As I understand it, the expert offered no opinion in his deposition on the one issue. But then he opined on an issue in his affidavit. It seems to me that the case law says if you opine the light was red and then you have an affidavit that said it was green, that's the situation where you have the conflict and you can't create it.
Right.
But here there was no opinion, then there was an opinion. So that case law doesn't apply. Is that your position?
Yes, and of course the only opinions given were the ones that were asked. And so you're right. And actually, just so I cover it, because it's related to that, there's been this issue raised about a substantial change affecting the condition of the vehicle. And that is in a product's case, if there's been a substantial change, and this is the reason we haven't sued Ford, because they made a substantial change, then you can't have a product's design defect claim. And so I think it's if you should look at the questions posed to Mr. Moore at page 15, 52, 53, and 54 about these modifications. Not once was he asked about a substantial modification. He was asked, was there a change? For example, the tires, the 40-gallon fuel tank, and the tuner. And he acknowledged there were changes. And he was asked, did these have an effect? And he acknowledged they had an effect. But then he was never asked, like their expert said in an affidavit, whether it had a substantial or large or significant effect. And so when he did his affidavit, if you read his affidavit, he still acknowledges those same effects. He says, yes, the tires from 35 to 37 inches will increase the rollover propensity. But it'll be very small, is what he says in his affidavit. So, again, I think the opinions are not inconsistent, and Your Honor is exactly right. The case law applies when you have contradictory opinions.
Well, I mean, isn't it, I have no opinion, and then I have an opinion. Isn't that a contradiction? I mean, they ask, as to Birkins, do you have any opinions with respect to the conduct of Birkins Chevrolet that you feel caused this accident involving Mr. Lesnik? Answer from Mr. Moore, no, I do not. And then in his affidavit, he has an opinion that Birkins failed in providing adequate warnings. So you went from no opinion to yes opinion, and here it is, right?
I think his opinion in his affidavit, to be fair to him, was to point out, and I don't frankly think we need this affidavit, because I think you can survive on what every dealer would know, but it's all in paragraph 5, where he points out the types of documents and information that any dealer would have access to. So that's, again, is he saying that he was not going to opine on the ultimate issue? Did the failure to give an adequate warning cause the injury to Mr. Lesnik? No, he didn't give an opinion on that. All he did was provide information that about what a dealer was. And if you read when Birkins' counsel examined Mr. Moore, it was very short and didn't ask much more than that. And I mean, Mr. Moore was not going to give an ultimate opinion, nor is he required to, for all the reasons I said a few moments ago. I do want to
Develop your thought just briefly for me about why you think you could survive without the affidavit.
Sure. First of all, because I haven't gotten through all the claims, but on the design defect, the Florida Supreme Court made very clear we look at what an ordinary consumer's expectations are. You don't need an expert for that. You need a jury of 6 people. And Mr. Moore, in his deposition, explained the dangers. Okay. On the warning claim, the question of whether a warning is adequate is also a quintessential jury question. All you need the expert to do is explain the dangers of the product. That whether the warning is adequate is determined, again, this is not a professional malpractice case. It's going to be determined by ordinary people. And the same applies for the negligence warning claim. I'm sorry, Your Honor.
What was the testimony of the plaintiff about his understanding of the vehicle and its lift system and all that? I mean, my quick reading of it was he didn't really know much about any of that stuff. But I'm not sure if that's accurate.
That is accurate. And at most, Your Honor, I think that would all come in Florida, we do allow in products liability both strict and negligence. You can have comparative negligence as a defense. So they can come back and say, oh, he knew this or he did this. They want to talk about all these changes he made to the vehicle. That's all fair game at trial. We just have to have enough evidence here to say we go to a jury.
Well, he didn't put the lift kit on, did he? I thought
no, but they're trying to accuse him of having made these 3 modifications and how that affected things, and that he was somehow negligent in that regard. Or if they want to accuse him of negligently driving. All those things will be fair game at trial. And as far as what he may have known about, I think that at most, that is really only relevant to the negligent failure to warn claim. And they certainly didn't put on the evidence that is conclusive as a matter of law. I see I'm into my rebuttal. I guess what I'll just say is on the warning claims I think the standard to reiterate is that the defendant did not adequately warn of a particular risk, known or knowable, in light of the generally recognized and prevailing best scientific and medical knowledge available at the time of the manufacture and distribution. That's how this court stated the standard in 2003. I'd also urge you to look at the jury instruction standard that the Supreme Court adopted 6 months ago. It's similar but slightly different. But I think the bottom line here is all this that I talked about, the notice from Ford, the warranty, their own warning they were giving, there's certainly a jury question about whether they knew enough and whether this warning, that even if they'd given the warning, they never gave the warning. They gave Mr. Sweat, Duval Ford gave Mr. Sweat a warning. I want to emphasize this point. They say they gave him a warning, and I read it. It's at page 1383 of the record, and that warning was never given to Mr. Lesnik or anything close to it.
How does Duval warn unknown potential future purchasers?
Well, the case law is very clear that when you put a product in the stream of commerce, you have to think about warning not just purchasers, any users. Because remember, products liability, there's bystander liability. You don't even have to be using the vehicle. If you go read the original West case from 1976 from Florida that established products liability, the plaintiff there was injured by construction equipment that basically didn't have rear view mirrors. So there's all types of questions whether you just hand the warning to the original owner. Is that enough? And I'll point, one thing they could do is affix it somewhere in the car. That could be an issue. And I want to also point to the Ford guidance. It says right here, if you no longer own this vehicle and you have an address for the current owner, please forward this letter to the new owner. Mr. Birkins didn't do that. This was out there when Birkins sold it. So you do have a duty under the law to warn subsequent users, not just owners, subsequent users of the vehicle. And the question is whether the warning here was adequate, and that's a question for the jury. Thank you. I'll reserve the balance of my time.
Good afternoon. I'm Hinda Klein here on behalf of Duval Ford. Birkins and I are going to split our time with me having 12 minutes and Birkins having 8 unless we're involved in some other questions and answers. With respect to the underlying issue of whether there was a design defect, I've heard some arguments on the part of opposing counsel today that are somewhat new and were not raised before the trial court. And that is the focus on the design defect aspect. We are not the manufacturer of this product. We were not the manufacturer of the lifted truck. And as opposing counsel has conceded, they are not pursuing Ford because lifting the vehicle substantially altered it. So in that regard, I don't really see how it is that Duval Ford could possibly be liable for a design defect when it designed neither the truck nor the lift kit.
What about basic negligence that you or client allowed the lift kit to be installed, I guess by an independent contractor, but nonetheless under the control of Duval Ford?
Well, there are no cases throughout the country, as I pointed out in my brief, that find lift kits inherently dangerous. And there's no testimony and no evidence whatsoever that the lift kit in this case was itself defective or was installed improperly. As a matter of fact, Mr. Moore specifically said he had no such evidence.
When you say inherently defective, you're saying
Or inherently
meaning
dangerous.
across the board in every instance. But
Correct.
Wasn't there some evidence to show that lift kits could be dangerous?
They could be, they could be dangerous if the person who was using the lift kit either improperly installed it or didn't operate the truck properly. It clearly says it does affect the center of gravity. And that was the express warning that was given to David Sweat when the vehicle was sold to him. And David Sweat testified in great detail that he was very much aware of it. And in fact, he drove this truck for about 2 years and almost 40,000 miles without any kind of incident. So absent any kind of evidence or testimony that the lift kit itself was defective and didn't operate as the consumer expected it to, there's no genuine issue of fact with respect to either the design defect or the negligence.
What about the testimony about the ball joints? I thought there was a conflict there where some said, no, it's company issued original equipment that was on this vehicle, but I think it might have been Moore that said, no, it was aftermarket.
Mr. Moore did have an opinion that he believed there were 2 ball joints that failed, and the ball joints that failed were aftermarket Chinese-made parts. The other ball joints on the vehicle were the original parts. There's no evidence, and it certainly makes no sense, that Duval Ford, who sold the vehicle when it was brand new, had anything to do with the replacement of aftermarket ball joints. And there's no evidence of record as to who may have installed those aftermarket ball joints. And we haven't been sued for doing that. So with respect to that issue, if anything, that militates against the plaintiff's case against Duval Ford, because they simply had nothing to do with replacing any original parts on this vehicle. I did also want to bring to the court's attention that Mr. Moore didn't simply say he didn't have certain opinions. He said he had no opinion and no evidence as to whether or not either of the defendants was negligent and whether either of the defendants had any causal relationship to this accident. So
What page are you reading from?
I am reading on pages 1540 to 41 and 1580, and on page 1487, Mr. Moore also testified that he did not believe lift kits were inherently dangerous, and he did, as the court had noted, testify that he himself has driven them more than a few times. And certainly I would assume that if an engineer believes something to be inherently dangerous, he wouldn't be driving it.
Do we know whether at the time of his affidavit, or at the time of his deposition, whether Mr. Moore had all the various documents that he recites in his affidavit? In other words, he talks about the pre-owned operations guide, the Ford pre-owned operations guide with lift kits, and so on, and the manufacturer's recall. The various things. Did he have those documents at the deposition?
I believe he did, but I can't swear to a judge. I haven't looked at the difference between his very lengthy 4-hour deposition and the affidavit, but he certainly didn't say anything in his affidavit such as, now I've had the opportunity to go back and see these service recommendations or anything else, and opposing counsel did not make the argument at the trial court or actually on appeal that Mr. Moore received any additional or new evidence that would account for his subsequent affidavits.
But you'd agree it's a fairly harsh result to strike an affidavit potentially disposing the case unless there's a clear direct conflict between the expert's former testimonies and his current statement.
I would, but I don't think that it made a difference in this case. I don't think either the affidavit or the deposition really addressed the specific issues before the court on summary judgment, especially once Mr. Moore expressly said he had no opinion and no evidence to support any kind of causation argument as against either of these defendants. But I would also point out, to be forthright, that with respect to Duval, the trial court didn't actually strike the affidavit directed to Duval. It only struck the affidavit directed to Berkins.
Let me ask about that. Lesnik mentions that in the brief, that the affidavit was stricken as to Berkins in the order granting the summary final judgment, but not as to Duval. Should we then send it back to the trial court to consider the affidavit as to Duval?
I assume that the court very well may have considered the affidavit as to Duval. I don't see anything in the record that said the court did or didn't consider Mr. Moore's affidavit as to the one party and not the other. The only mention of it in the court's order was that it was stricken on Berkins' own motion. So,
and I've looked at some of the Futch and Elkins and some of these other inconsistent evidence cases, and I'm not seeing either a clear requirement to move to strike the affidavits or that, to the contrary. So,
well, actually, my trial counsel, Mr. John Howell, who I neglected to introduce to the court, did in fact make the argument that the court shouldn't consider it or should strike it, but did so orally, whereas Berkins had a written motion to strike, and it just may be that the court overlooked it. But I don't think that Mr. Moore's affidavit with respect to Duval had any effect whatsoever. His ultimate opinion was that aftermarket Chinese ball joints failed, and that the original ball joints wouldn't have failed. And we sold the vehicle brand new to somebody else 2 years and 40,000 miles before this happened. And in that period of time, after Mr. Lesnik bought the vehicle, he increased the horsepower from, I think it was between 3 and 362 horsepower by a third, added a heavy toolbox and fuel tank, added additional wheels of 37 inches, which were not the original wheels on the tire, were not even the original wheels which were part of the lift kit, which were 35 inches. So all of the modifications that Mr. Lesnik made, even Mr. Moore specifically said, that clearly made it completely different than it was at the inception when the vehicle was first sold, as lifted to the original purchaser, Mr. Sweat, which is the only purchaser to whom we owe any kind of a duty.
Well, let me ask you about their theory, because they're saying, fine, there were subsequent modifications made, I guess by Berkins. I assume it was Berkins that made the subsequent modifications. But they're saying, wait a minute, you, Duval Ford, under your control, had this lift kit put on by an independent contractor, but it was something you did as a part of the sales process. And there's some evidence that shows that you were supposed to pass on the information later obtained to anyone that purchased this. It's almost like a quasi-recall and whatnot. I mean, that's too harsh a phrase, but it's basically, you need to tell other folks there's a problem here. So is it your legal position that once you sold the vehicle to Lesnik, or once it was sold, I'm sorry, to Berkins, once it was sold to the second purchaser of it, to Lesnik, Sweat sold it to Berkins, whose daughter was dating Lesnik, all right?
Correct.
Got it right? Okay. Don't you have some obligation under their theory to at least let them know there's a problem here?
That's assuming that you knew it was transferred. How would anyone know that unless they were the ones that resold the vehicle? The vehicle...
But wouldn't you have put Berkins on notice, passed along the information to Berkins, so Berkins can let purchasers like Lesnik know? I
do recall that there was something in the record that, in fact, we did, that there was a service recommendation sent to Duval, and that there was an additional notification in 2009, which Ford sent directly to the owners of the vehicles. Mr. Sweat could not recall whether he had received any of those notifications.
Is this duty to inform to a subsequent purchaser is that resolved as an issue of law, or is that resolved as a jury issue?
It's got to be an issue of law, because there's no way for a dealership to constantly keep track of when vehicles are transferred to other people, and that would be
So
an
your
unfair
position is
burden
that-
that I'm not aware of in
As
the law.
a matter, as a question, as an issue of law,
Yes,
you had no duty to a subsequent purchaser
That's-
of a modified vehicle.
correct. Especially where, as in this case, the subsequent purchaser then further modifies the vehicle so that it's not even remotely similar to the vehicle in its
left your
condition
lot.
when it was originally sold. And I did want to point out that Mr. Sweat was in fact warned at the time that he purchased the vehicle, and at the time he had the vehicle lifted in accordance with the warning from Duval, which said, "Warning, please read. The installation of a lift kit will modify the suspension of your vehicle and increase the ride height and will cause the vehicle to handle differently than a factory-equipped vehicle and may increase the risk of vehicle rollover." Mr. Sweat got this and signed this warning. I don't know whether or not he passed it on to Perkins or to Mr. Lesnik, but he clearly did in fact receive a warning, and there was an additional warning in the owner's manual as to the effect of altering the suspension of a lifted vehicle. And one more thing, it did not void the warranty. The only problem with the warranty after a vehicle is lifted was that any part damaged by the lift kit would not be covered under the warranty, but the truck remained covered under the warranty.
I know your time's running down. Maybe the presiding judge will give a little extra time. But I'd like to ask this question. What benefit is there to the lift kit? What is the benefit to the consumer of having a lift kit installed?
You know, I don't really understand it myself. According to Mr. Sweat, who liked the way it looked, it made it taller. Maybe that's the reason people do it.
So there's an aesthetic value, perhaps. But
I
is there any
believe that's it.
mechanical, or I always assumed it was because they go through floods easier, floodwaters.
Well, it does raise the ground clearance somewhat, so I suppose that would be a benefit. But other than that, I don't have any
You
personal
can also
knowledge.
pick up mud a lot better.
Off-road possibilities.
Right. Other than that, I don't see a benefit.
We're going to add 60 seconds to council for both sides.
Thank you.
Thank you very much.
Good afternoon. May it please the court, I'm Shelley Leineke on behalf of Perkins Chevrolet in this case. Summary judgment was properly granted in favor of my client, and the only claim against Perkins was an allegation of negligent warning of the rollover propensity. And I offer to the court that Mr. Lesnik had knowledge of this. The owner's manual that accompanied this vehicle says in several places that utility vehicles have higher propensities to roll over. You have to be careful how you drive them. Don't use excessive speed, etc. Not only do we have that knowledge,
Is the issue of the adequacy of the warning
the issue is
dispositive at all?
the question is whether my client had a duty to warn, and there is no duty to warn, A, about latent defects, and B, even a patent, even other defects. If the party to whom the warning should be given has equal knowledge, then it's basically no harm, no foul. There's no negligence there for not warning. So we take the position, and I think the trial court correctly determined, that certainly as to the high center of gravity and rollover propensity and things of that sort, Mr. Lesnik had knowledge whether we gave him any warning or not on this, because it was contained in the Ford Motor Manual, and Mr. Lesnik acknowledged that he had gone to monster truck jams and things of that sort and knew that a lifted vehicle had a higher propensity to roll over than something low like a sports car. And then he changes the car. It even further. It came with 35-inch wheel, or 33-inch wheels, excuse me. When it was originally lifted by Mr. Sweat, it was changed to 35-inch wheels. He then changes it to 37-inch wheels, raising it even
Who did
more.
those, I'm sorry for interrupting you. Who made those changes? Was it your clients?
No,
or
no, Your
someplace
Honor, it
else?
was not. It was Mr. Sweat. Pardon me, it was Mr. Lesnik that made those changes. After he bought the vehicle, he added these various enhancements to it in the couple of months between when he purchased it and when this incident occurred. My client had nothing to do with the further lifting of the truck, if you will, or adding this additional weight that made it even more top-heavy. And it, again, as counsel for Duval Ford said, the truck operated without any problem at all for a couple of years, and then these problems occurred after Mr. Lesnik made these changes. The case law says that, as I mentioned a moment ago, a seller who is not a manufacturer has no duty to inspect for latent defects, and these issues about the ball joints and worn parts or the suspension assembly, my client had no obligation to disassemble these parts, which would be the only way they would know about it.
Well, let me, if I could interrupt again. The theory of the plaintiff's case is your client got the warnings about this lift problem, and so is the record without any evidence that your client had
Certainly,
noticed?
my client had no notice from Duval Ford about this, nor would a Chevrolet dealership be receiving anything from Ford Motor Company.
But what about, I mean, regardless of what Ford provided you, or Duval Ford, I should say, did your client have notice of any information about the risks of the lift system?
It is alleged in Mr. Moore's affidavit, which we believe should not be considered. It said that Chevrolet's certified pre-owned operation guide, and I'm adding for its own vehicles, excludes vehicles that have been suspended or had tire modifications. I have no understanding how or why that should be relevant to what Ford does or how that works with that. But they're saying that we should have trade knowledge just because my client sells cars, that we should have some inherent knowledge of the dangers of lift vehicles and should have passed it on. More directly, paragraph 6 of his affidavit says that my client should have warned the consumer of the risk of lifted trucks because it's not obvious to the consumer, and the risks include premature component failure and higher rollover propensity. Well, my client, there was no premature component failure known. The truck had been taken apart and inspected, I think, as part of the modifications Mr. Lesnik did. I think it was some 6 weeks before this incident, and the ball joints that later failed were looked at, and they were not a problem at that point. So certainly, not only did my client have no obligation to do this disassembly, even if it had, the parts would have been fine at the time my client would have looked at it, and Mr. Lesnik already knew of the higher rollover propensity. So,
But does that just clean the slate for your client simply because he knew about the risk? I thought at least if you didn't warn about it at all and he learns about it through secondhand information, because you're saying he knew about it, but you didn't. So what's going on?
we didn't have any obligation to warn him of any rollover dangers because he had equal knowledge, and the law has been very clear for as long as I can remember that you only have a duty to warn of something where you have greater knowledge, and the plaintiff had knowledge of the rollover propensity. And we don't have any obligation to warn of something obvious. It was clear this truck was lifted. We had no obligation to say, Mr. Lesnik, you're buying a truck that's higher than it came off the assembly line.
But this guy is dating the dealership's daughter at the time.
Yes.
Okay. And does that have any role in this? I mean,
Probably not.
no. I mean, there's an inference here that somehow this. Oh, it must have been safe because he wouldn't have let his daughter drive in it.
I think as a matter of
Right.
convenience or courtesy or assistance in title transfer or however it may have been, I'm speculating off the record that my client got involved in the transfer of the vehicle from Mr. Sweat to Mr. Lesnik. But my client's obligation or duties in this case were the fact that he was dating my client's daughter has nothing to do with it. I think the issue of
Watch your time.
thank you. Moore's affidavit was properly stricken. He had, as in his deposition, he said, I have no opinions or evidence of anything wrongdoing by Birkins Chevrolet, but yet he has this affidavit that says, well, Birkins Chevrolet should have given a warning. But even if you consider that affidavit, or if it was inappropriate to exclude it, it was harmless in light of Mr. Lesnik's own testimony that he was aware of the rollover propensity. He had personal experience with the vehicle shaking, and he had this information from the manual concerning the rollover propensity. We would ask for an affirmance of the summary judgment.
Add an additional minute to opposing counsel.
Thank you for the extra time. I think all the questions that have been asked by the panel and should show that this is a case that needs to go to the jury. I mean, we're getting into what Mr. Lesnik knew, apparently. They can argue those things to the jury. This is not a case ripe for summary judgment. And there's a number of things I'm going to try to tick off as quick as I can. First of all, the fact that Duval Ford claims now it wasn't a manufacturer. Products liability law, Hornbook 101, the manufacturer, the distributor, and the seller are on the hook for all three theories: design defect, manufacturing defect, and warning defect. So call themselves what they want. The reason they're the manufacturer is that they installed the lift kit. Mr. Sweat's testimony was unequivocal. He had no dealing with the contractor. He paid everything to Ford and asked them to put the lift kit in. Number two, this talk about that Mr. Moore didn't say it was an improper lift. That would be a manufacturing defect claim. If we said the way you did the lift was wrong, or you put in the wrong part. Design defect is you shouldn't have put a lift on this truck.
But he had no opinion, and then the defendant's expert said there's nothing inherently dangerous with a lifted truck.
Right, and the Florida Supreme Court has instructed that expert's opinion, we're going to move to strike, because what they've made very clear 2 weeks ago is the standard is ordinary consumers, not what experts think.
So do you never get summary judgment in a products case
No,
if it's what ordinary consumers think? We have to come forward with evidence of dangers in the product. But whether or not the product is unreasonably dangerous is for the jury. And we've presented evidence of dangers. Increased propensity for rollover. Excessive shimmying, which is what Ford itself says, as well as the premature parts. We've shown dangers. Now the question is, from the juries, maybe there will be some jurors like Mr. Sweat who said, hey, I expect those dangers. Maybe they'll win in front of a jury. But how is an engineer what is an engineer's qualifications on an ordinary consumer? And that Florida Supreme Court used those terms again and again and again in the opinion 2 weeks ago. So I don't think any of these engineers can weigh in on what an ordinary consumer thinks. They can only inform the jury based on their technical knowledge about what the dangers are. And then the jury makes the call, just like it would in a lot of other things, about whether that's an unreasonable danger. The ball joints are a red herring, and let me try to explain why. Their position is that they didn't install the ball joints, and we have some debate about that, but accept their position. That's something they can use to try to have the jury put fault on whoever did those ball joints. They want to Fabre the Chinese manufacturer? Fine. They want to Fabre the party that put the ball joints in? Fine. They want to have comparative negligence against Mr. Lesnik? Fine. But our expert's theory was that the ball joints were the last part to fail, that it was the excessive shimming. Their expert's theory is it's the ball joints. This is a jury question. Okay? So even accepting that they did not install the ball joints, it's a jury question. And if they want to Fabre somebody in, fine. But it should go to the jury. I want to be clear about the affidavits, Judge. There's two.
One was written really for Birkins and the other.
Got them both here.
Okay.
Pretty clear.
So the judge, as she conceded correctly, the judge never struck the Duval Ford affidavit.
But doesn't under Elkins and Futch and the other cases, whether it's stricken or whether it's just disregarded, does that matter? I mean, is there, I've not seen a requirement that you must move to strike a bad affidavit that's inconsistent.
Well, I don't know how else the other party would be on notice if there wasn't such a motion.
Well, Mr. Howell argued it at summary judgment.
At the last minute at the hearing, and we, argued the other way. She didn't say in her order that she was striking it. I don't know what else to tell you on that. I think that as Judge Makar, by some of the questions he's posed, we don't think there's any inconsistency. So, I'm sorry. I'm sorry.
I was just going to ask you quick before you ran out of time.
Yes, sir.
As to Birkins, they did an inspection in a normal walkthrough. They didn't take the ball joint apart, obviously, not a normal walkthrough. The shimmying that started occurring was after the sale was completed. So any duty or any knowledge of any kind of defect, wasn't that after the sale was already completed?
No, because of all the literature that any dealer would know. Plus, I'd like to point out Mr. Birkins personally purchased and lifted F-250 truck the same time Mr. Sweat did. And apparently got the same warning. There's lots of fact questions, and I see I'm out of time, and you've already given me more.
Thank you very much, counsel. I'm going to excuse counsel. If the students choose to stay and ask a couple questions, the court will be happy to do that. We'll give counsel a couple minutes here to clear out and take any questions from the students.